Good morning, friends. Welcome to our Managed Legal Information Wonderland. Explore the magic of bricks and builds online platform with your or our YouTube channel. So do not forget to subscribe this. So today I am bringing a content which is continuity of what? Which is continuity of our playlist formulation of drafting of commercial contract. So this is a continuity, and right now today we will discuss about breach of agreement clause. So within this particular content, we will discuss about the introduction part with example, then types of breach, legal remedies available, then how you can make prevention, that is prevention to breach. What is breach of contract? Breach of contract occurs when one or more parties involved in contractual agreement fail to fulfill their obligations. So what are these obligations? I explain you through an example that for Audi, there is a Virat Kohli is acting as an ambassador, and for Tanish, there that Deepika Padukone act as a
Best Actress जीत
brand
निकली
ambassador. Both of these are binding by an agreement as an brand ambassador agreement, where what are their responsibilities and duties. These are actually what terms and conditions which they need to form, and these terms and conditions are legally binding within both of them. So first of all they need to promoting the company membership, or not company membership, promote the company brand. If Virat Kohli involves in Audi and Deepika Padukone for that as an ambassador for Tanishq Tanishq product, then they are not going to promote any other brand such as Mahindra, Hyundai, and Deepika Padukone shouldn't that promote Malabar, and even Reliance Jewelry is present. They are not going to, and in addition to that, they are going to participating in marketing events or efforts, and they also available for interviews. These are the clauses which I am discussing, which were present in the agreement as an obligations. So videos and photo shoots they were involved, and they can that company can use their image to promote their brand. At last, social media also they will promote. You have seen that different that various actors or actresses, they if they are in clothing sector, they wear the particular brand clothes. So this is all what this is a promotion techniques or tactics. So what are the types of breach? Types of breach are material breach, minor breach, and anticipatory. So starting from the very first, my material breach is what? It is a significant violation that goes to the core of contract. Means it is the basic part obligation which is involved in the contract. Here, if we talk about the above example, where promotion is the basic criteria, if they are not promoting that particular brand, if instead of wearing using that instead of promoting this particular car of brand, that Virat Kohli is starting promoting any other brand, then it is material breach. This is the base or core of the contract. So this needs to be followed. It allows the non-breaching party to seek that if they can do that accordingly, whatever losses occur because of these activities, the non-breaching parties can seek damages to terminate the contract. Second one is the minor breach. Minor breach is there. It can be settled, or it is not that it may create such a major losses. For example, if a particular distributor is having the agreement with the retailer for the distributorship, where where the distributor send 100 laptops according to the requirement of the retailer. But what happened on that particular day delivery or dispatch of those laptops hasn't occurred. So what is there? Because of that one to delay, if what happens, one or two customer not able to pick up those products, because of that they reject or cancel our order. So in that cases, it involves a less significant failure. So what happened? The non-breaching party is entitled here also in damages, but in that case termination is now not option. So what is termination? Termination occurs when party or party is not following the obligations properly for continuity for a longer period of time. that may breach to continue then terminate the contract, or if it punch on the base of the agreement, then termination takes place. In material breach, most of the time termination takes place. Third one is the anticipatory breach. Anticipatory breach is that it occurs prior to the formation of agreement, where both of these parties are negotiations. They in the above case, if they stated that from 31st of January 2024 there's a small meeting prior the formulation of this agreement. But what happened, neither both of them neither that for formulation of this agreement, no, none of them is present. Not none of them. If I take above example within Audi, Virat Kohli was not present before formulating of agreement, then this is anticipatory breach. It occurs when party through his action or through his words or actions they don't want to fulfill their contractual obligation. So non in this case, both that other parties say they primarily indicated from this these their words and action that he or she is not interested in contract, or either he she or even that company or firm is not interested. So non-breach party either to choose to terminate a contract or seek the damages. Damages what, the expenses occur for conduct a meeting. Last one is that there's the next is the legal remedies. What are the legal remedies available to them? First one is the damages. Damages are two types: liquidated or unliquidated. Liquidated damages are those damages which you can calculate prior. Calculation can be done prior. So monetary compensation awarded to the non-breaching party. Now designed to cover losses incurred due to breach. Now and unliquidated damages are those damage which are futuristic in nature, which you can't predict. For this, if real estate contractor made a contract that this particular flat is 1 cr, required this much of material, but appreciation of this building price will takes place. In addition to that, that if possession is not provided on that particular day, then what happen, those parties which are residing on rent, they give rent at particular place which they are residing. So calculation of those breaches done on the basis of future, any breach according to the future calculation, it can't be predicted right now. That is unliquidated damages. Specific performance, if it requires the breaching party to fulfill their contractual obligation as outlined in agreement. If they don't fulfill that agreement, if there's a requirement that you need to form these number of flats within up to according to RERA 31st of January 2024, but you are not able to fulfill, but you apply for the suit within the court, and they said that after 90 days you are going to perform this obligation and hand it over these flats to the particular parties. Third one is the rescission. Rescission is involved cancelling the contract totally and restoring the party to their pre-contractual position. What is at the beginning, you reach at that particular place. These are rescission. It is also remedy common in cases of fraud, mistake, or impossibility. So what prevention you can take? Prevention you can take, clearly define the rights and responsibilities, obligation of each party. If you not identify or define all these rights and responsibilities of each party, then it is what, it is particularly a breach. Then communication, maintain a open transparent communication. If there is any problem occurs between both of them or confusion, then properly communicate with them that the state shouldn't reach for alternate dispute resolution. If a state reaches for alternate dispute resolution, then what you can do, you may use alternate dispute resolution. It is better to terminate to use alternate dispute resolution where mediation takes place between parties on the clauses where this breach actually takes place. In addition to that, there's a particularly right now important Cisca. You know about Cisca LED, where the what happened when the one of the customer purchase a power bank, where the company not able to the repair that power bank. So it is also breach because it comes under the terms and services which need to be provided by. So this is, it is a deficiency of service. So in that particular case, that damage is provided. This is a current case, 20th or 21st somewhere. Then third one is that second one is the UPSC Pathshala. What happens in UPSC Pathshala, that that particular one student purchase that cost rupees 40,000. Then what happened that according to what are the terms and condition, that they provided you updated material, they provide you that reliable services, they haven't provided to that student, then he asks for those refund according to condition it is written. If it shouldn't be find out suitable for a candidate, then within 30 days we will refund those these specific fee or amount but what happened, they haven't refund the amount up to 52 days. So in that case, the particular student, it is a breach of in a breach of the contract in within agreement, it should be provided by the UPSC Pathshala. The third one is the is also current JC, related to JC machinery, that where in I think so this is Ernakulam district commission is hold that manufacturer is liable for faulty machines, that they are providing faulty machines to the customer, so where they order 1.5 lakh compensation. The breach of contract is very important, there's a lot of remedies should be available with them. So how do you find out this video? So this is a playlist right now going on, and more number of topics are related to them. First of all, I am going giving you a definition of part, so basic understanding can be created. After that, practically I form a draft, so you maybe remain connected regarding that. Those who are student of law or professionals may take advantage from this. Thank you.